Montehermoso versus Batuto, GR number 246553, December 2, 2020. Facts of the case are as follows. So the case arose from a complaint for cancellation of title, reconveyance, and damages filed by the respondents Romeo Batuto and Arnel Batuto. They claim that a 44,410 square meter piece of land, which rightfully belonged to them, was erroneously included in the original certificate of title or OCT number 5781 of the petitioners, the Montehermoso family. Now, on March 8, 2015, the regional trial court ruled in favor of the respondents and ordered the reconveyance of the disputed property to them. Now, petitioners Marilyn, Tani, Emma, Eva, Teresa, and Salvar Montehermoso appealed the RTC's decision, but their appeal was dismissed by the Court of Appeals on August 5, 2016. Now, the decision became final and executory on September 9, 2016, after which a writ of execution and demolition was issued. However, the petitioners continued to file multiple legal challenges. First, Tani Montehermoso filed a petition for relief from judgment, which was dismissed by the CA on September 27, 2017. After the denial of Tani's motion for reconsideration, petitioners attempted to seek reversal of the CA's resolutions through a petition for review before the Supreme Court. But the Supreme Court denied their petition on August 6, 2018, citing a lack of reversible error on part of the CA. On the 3rd, the petitioners filed yet another petition for annulment of judgment before the CA, arguing that the trial court lacked jurisdiction over the case. This petition was also dismissed on February 13, 2019, and the motion for reconsideration was denied on April 10, 2019. Finally, petitioners filed a Rule 45 petition before the Supreme Court to assail the CA's resolution on the annulment of judgment. Now, over the course of 5 years, despite the finality of the RDC's decision in 2016, the petitioners continually challenged it through various legal means. So the issue of this case is whether or not the petitioners can continuously challenge a final and executory judgment through multiple legal actions, invoking various grounds for its annulment, even after the judgment has long attained finality and has been implemented. So the court held that no, the petitioners cannot continuously challenge a final and executory judgment through multiple legal actions invoking various grounds for its annulment after the judgment has long attained finality and has been implemented. The Supreme Court denied the petition for review on certiorari and affirmed the CA's resolution dismissing the petition for annulment of judgment. So the court emphasized that under the doctrine of immutability of judgment, a decision that has become final and executory is immutable and cannot be altered, even if the modification sought are to correct errors. Now, the court condemned the petitioners' repeated attempts to challenge the already final judgments and warned them, along with their counsel, against further efforts to revive the case. The court reminded that once a judgment attains finality, litigants are barred from filing further actions that disturb the final decision. So once a decision becomes final and executory, it becomes immutable and unalterable, and no court can modify it in any aspect or any respect, even if the modification is meant to correct erroneous conclusions of fact or law. Now, this doctrine protects the finality of judicial decisions, preventing endless litigation and ensuring the stability of judicial rulings. So the court explained that a lawyer's duty to uphold the cause of justice is superior to his duty to his client. Lawyers are reminded that their loyalty to the courts and to the legal system must come before their clients' desires to continue litigating, especially in cases where there is no merit. The finality of judgment is an essential principle in the judicial system. It is an important fundamental principle in the judicial system that every litigation must come to an end. The prevailing party should not be harassed by subsequent suits. Thus, the Supreme Court disposed the case in the following manner, to wit, wherefore the petition for review on certiorari is denied and the sale resolution dated February 13, 2019 and April 10, 2019 of the Court of Appeals in CA GRSP number 159373 are affirmed. Petitioners, as well as their counsel, attorney Belinda M. Nagui, or any other counsel who may take over this case, are sternly warned that any further attempt to revive this case in whatever form and before any forum will be severely sanctioned.